Did you know there are two essential documents every investor needs when they're setting up a land trust? If you didn't, then watch this video because I'm going to go through what you need if you're going to create a land trust to make sure you can sell that property in the future and take care of your investments. All right, let's get started. Okay, so here's the deal. I was recently approached by an individual who had set up multiple land trusts with another law firm. And these land trusts, they're okay documents that have been created, but they were missing two crucial documents that need to go with every land trust when it's getting created to ensure that the individual who is transferring property into the trust is going to be able to effectively dispose of that property in the future, or if they wanted to refi the property, that they're not going to cloud title to the assets that are held in that trust. Now, what am I getting at here? Let me just show you basically what we're talking about with a land trust. So one of the reasons why individuals like to create land trusts as real estate investors is for anonymity, all right? So we want to hold title to our property and not have our tenants know that we own this property because it's no longer in our name. So an easy way to do that then is to create a trust. So we create a land trust here. And let's say we have this individual over here, his name's Ben, that owns this property. Well, he sets up the 123 main trust. So that's the name of the trust that we've created. But the thing is that Ben cannot be the trustee of his own trust, because when you transfer title into a trust and you want anonymity, you can't put your name on as trustee of this trust, or that is the initial trustee. So what we'll do is we'll use a nominee trustee, and that is someone other than Ben. Now, many times you'll end up using an attorney. I've served on thousands upon thousands, I don't know, probably 12, 13,000 different trusts my name appears on as a nominee trustee. So you appoint your initial trustee, that's also how we refer to this, you know, an attorney, or maybe you're using an LLC. So in my case, it would say Clint Coons, trustee of the 123 main trust. And so I'm listed there as the trustee on this trust. Ben's going to be appointed the beneficiary. So he's the owner of the trust down here. So it's the trust beneficiary is Ben. I'm the initial trustee. Now, Ben understands the reason we're doing this is so that when we deed the property from Ben's name into the trust, he will no longer appear on title because Ben was the grantor on the deed. The grantee, the person who's taking title, is Clint Coons as trustee of the main trust. So there we go. Now we have anonymity of ownership. Ben, you're no longer the owner. No one knows this because the trust agreement is not recorded anywhere. That's how we maintain that privacy. Now, obviously, as the trustee who's listed on that trust agreement, I don't want anything to do with the trust. I'm there just to help Ben out, to get him the anonymity. And once that's accomplished, I resign my position, and Ben is listed in the trust agreement as a successor trustee. So upon my resignation, he steps in and now he's in control of the property. So all of that works. Now, this is where we get to the point where the individual or the attorney that drafted these trusts for this client of ours made two crucial mistakes. And if you're setting up a land trust, do not make these mistakes if you're doing exactly what I'm describing here. So what is the first mistake that was made? The first mistake was in the resignation on that trust. So in the actual trust agreement itself, it stated that upon funding of the trust, the trustee shall resign their position. Now that's in the body of the trust. And in my experience, what you need to do when you're dealing with title, they want something more substantial than that. They want to see that the trustee actually had the intent to resign their position. It's typically not enough just to put that precatory language in a trust agreement and assume that a third party is going to be there. So when it comes to the resignation, you want a separate document from your trustee, okay? So every time I resign my position, I draft up a resignation letter. I state that I resign my position as trustee and that I'm turning it over to the successor trustees. And I sign that document and I provide it to my client. So what it shows there is that, yes, I had the intent to resign my position in that trust, and I no longer want to be a trustee of that trust. So I think that's really important as well. I was recently dealing with a client who was selling property in a trust, and that is what the title company wanted to see, that I had formally resigned my position. Okay, that's important, but the most important document you're going to need is a trustee deed. All right, this is crucial. And if you don't have this, you risk clouding title to your property and making it difficult to sell in the future or do a refi. Now, what is a trustee deed? Now, remember in my example, what Ben did is Ben deeded the property from his name to Clint as trustee. Okay, so I'm on title. And if Ben tries to refinance this property or sell this property, the title company is going to wonder, where is Clint? Now, Ben can give him my resignation. You might think that's sufficient. In my experience, that only works about 10% of the time. And so relying just upon a resignation to put you in a position where, yeah, you're in control and, of this trust, and a title company is going to look at it and say, oh, I see here, yeah, Clint resigned and you're the successor trustee. So yeah, we'll just allow you to deal with the asset and we'll accept that. Doesn't happen very often. So you need to cover your bases. And a resignation or a trustee deed, what that does for you is it's a deed from the trustee back to Ben as a successor trustee. So every time a trustee, a nominee trustee resigns after title's been taken in the trustee's name, so it says Clint Coons, trustee of the main trust, what I end up doing and what you should get from your nominee trustee is I'll draft a new deed called a trustee's deed, where I'll say Clint as trustee of Main Street Trust hereby conveys blah, blah, blah to Ben as successor trustee of the Main Street Trust. And I give that to Ben, I sign it, execute it with all the required formalities of a deed, and I provide that to him and I say, all right, here's your trustee's deed, Ben. Hold on to this deed, and then when you're ready to refi the property or sell the property, if you have run into any problems by just providing the resignation letter and they won't accept that and they want to see your name on title, you can now record this deed and it'll put your name on title because I've deeded the trusteeship back to you. This document is crucial. It has happened before where I've dealt with clients that have been trying to sell property or refinance property. The person that they use as their nominee trustee has disappeared. They can't find them and they get stuck and they have to open up a legal proceeding to clear title to your property. So if you're dealing with someone who's setting up a land trust for you, or you're going to set up your own land trust, make sure if you're using a nominee trustee, you always prepare a trustee's deed. It's going to protect you down the road. Hey guys, if you liked the video, smash the like button. And if you want to join me at one of my upcoming tax and asset protection workshops, it's a free event, one-day event. I got a link right down below. Go ahead and check it out. You'll get all your questions answered when you come there because I bring together attorneys and CPAs and we go really deep into business entities and tax planning for real estate investors. Take care.